Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. It is Saturday afternoon, and I'm sitting in the studio. Why the hell am I doing that? I never come into the studios on Saturdays. Well, it appears that we got some really big news late Friday about your new and improved United States Department of Justice and their willingness to weigh in on Illinois' very unconstitutional assault weapon ban and magazine ban. And what makes this huge is this is not before the United States Supreme Court. No, the United States Department of Justice is actually going to get involved in this while it's in the Court of Appeals. We're going to go through the memorandum, but I want all of you to really understand what a huge day this is for your inalienable rights and what a huge day it is for the Department of Justice as well. So today, let's spend a few minutes, let's go through the brief, and let's talk about when the Department of Justice calls BS on Illinois' gun laws. Okay, America, listen, in the panoply of assault weapon bans and magazine bans that we've had a chance to cover here at Washington Gun Law, no ban has been covered more frequently by us than Illinois'. I know we are called Washington Gun Law, and yes, we have had magazine bans and assault weapon bans shoved down our throats here as well, but the way they did it in Illinois was absolutely so rotten and nefarious it had warranted that much attention. The cases are all now before the 7th Circuit Court of Appeals, and today we're going to be talking yet again about the case of Barnett v. Raoul. But we're talking about an immensely important amicus brief, a brief that was filed by the United States Department of Justice on behalf of the petitioners who are saying that, hey, the trial court's ruling here should be upheld. You guys all may remember that Judge McGlynn down in the South District of Illinois actually conducted a full 3-day trial, found shockingly that both AR-15s as well as large capacity magazines are in common use for lots of lawful purposes, and struck the law down and enjoined it. Of course, the 7th Circuit got involved, screwed it all up, and here we sit today. Now listen, I want you guys all to realize what a huge thing this is. We're going to touch on the brief here in a moment, but I want you to realize that we thought it was a big deal when the United States Department of Justice filed an amicus brief in support of the petition in the matter of Wolford v. Lopez. You may recall that as the case out of the Hawaii State Supreme Court that basically says the aloha spirit trumps the Second Amendment. And that was a big deal. It was a really big deal when the United States Department of Justice did that. But what we're talking about today is the United States Department of Justice filing an amicus brief in support of lawful gun owners in the state of Illinois before this case has even petitioned to the United States Supreme Court. This is taking place in the 7th Circuit. The United States Department of Justice makes 3 primary arguments in their amicus memorandum, and they are: Number 1, the act violates the Second Amendment by banning AR-15s and other firearms that are in common use by law-abiding citizens for lawful reasons. Number 2, text, history, and precedent confirm that a legislature may not ban a class of weapons on the ground that the weapons are militaristic. And finally, the act violates the Second Amendment by banning the possession of magazines and other firearm attachments that are in common use by law-abiding citizens for lawful reasons. Now, turning to their first point here, which is that the act violates the Second Amendment by banning AR-15s and other firearms that are in common use by law-abiding citizens for lawful reasons. The United States Department of Justice very wisely points out, in this case, the key question under the Second Amendment's text is whether the banned semi-automatic firearms are arms. Many of them, including AR-15s, are. Over a century of state precedent, after the framing confirms that rifles were understood to be part of this category of arms. That's right, you may recall that the 7th Circuit actually found that these are not even arms that are protected by the Second Amendment. That is literally the way they tried to wiggle their way out of it. And the United States Department of Justice correctly points out, like other rifles have since the founding, AR-15s fall squarely within this category. They are worn, borne, and carried for offensive or defensive action in case of conflict with others, thus satisfying Heller's expansive definition of arms. Now, you may recall we did this video right here, which was about this really fantastic amicus brief that had been done in the case of United States v. Brown, a challenge to the federal regulations of automatic weapons. And what we loved about the amicus brief was it really just got back to the basics, okay? It really was Second Amendment Protections 101. Now, I think that the United States Department of Justice has done an excellent job here as well. They've gotten back to the basics and they are pounding away at the core principles, the very same core principles that we talk about all the time here at Washington Gun Law. One of which being that the types of arms that we're talking about right now are absolutely positively considered arms and therefore protected by the Second Amendment, as the Department of Justice puts it. But the AR-15 does not fall within this unprotected category. As explained below, the AR-15 is in common use by law-abiding citizens for lawful purposes, including self-defense, target shooting, and public defense. Once an arm is in common use, its mere possession cannot be infringed or forbidden by the legislature. And as the United States Department of Justice correctly points out, listen, this is a very simple, straightforward equation. This is the common use test. There is simple numerical value that we need to establish here. Are these firearms commonly possessed for any lawful purpose, as they correctly point out? As Heller explained, the common use test is supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons. That is a conjunctive test. A weapon may not be banned unless it is both dangerous and unusual. But then they also very correctly point out AR-15s fall squarely within the Supreme Court's common use test. The AR-15 is the most popular rifle in the country, as the Supreme Court recognized in a unanimous opinion just days ago. Oh, don't you just love it when the Supreme Court's own precedent, especially that of a liberal justice, comes back to haunt you? Yes, I do. DOJ concludes it with, not only are AR-15s in common use, but the overwhelming majority of AR-15 owners use them for lawful purposes, including self-defense and target shooting. And the Department of Justice is adamant that because these arms are in common use, a flat-out ban, as what occurred here in Illinois and several other states, is simply not permitted under the Constitution. Applying the Supreme Court's Second Amendment case law to this question, AR-15s are in common use by law-abiding citizens for lawful reasons. Under Supreme Court case law, that is all that is needed for the citizens to have a right under the Second Amendment to keep such weapons. Okay, and then as you recall, the Seventh Circuit had ruled that because these weapons are more appropriate for military use, then therefore they are not even protected by the Second Amendment. That is actually what the Seventh Circuit ruled. The United States Department of Justice does a pretty good job of dismantling this position without coming right out and calling them freaking idiots. As DOJ put it, this court's non-militaristic limitation on arms protected by the Second Amendment is wholly unmoored from history. And going through a litany of case law that clearly spells out and corroborates where DOJ is coming from, they also mention, these facts demonstrate that this court's view that the Second Amendment does not protect militaristic weapons is at odds with our nation's history of citizens possessing, and indeed sometimes being required to possess, weapons that would be useful in various collective self-defense contexts. Given this history, the purported militaristic character of a weapon does not by itself justify prohibiting it. That is absolutely true. As a matter of fact, if you go back and you take a look at some of the older case law, those who were members of the militia were expected, it was almost demanded of them that they would be able to appear with the most modern and lethal weapons known to man, which begs the question, do we as American citizens, are we actually entitled to access to a larger amount of firearms than what the federal government currently allows us access to? And this is a huge issue that needs to be cleared up right now, and that's why DOJ is telling the Seventh Circuit, hey, you need to clear this up, as they put it. Text, history, and precedent reject the view that militaristic weapons are not even arms under the Second Amendment. This court should make clear now that this case has reached final judgment. And then, of course, we have to move beyond the assault weapons or semi-automatic rifles, shotguns, and pistols that were banned by the Protect Illinois Communities Act, because there was also a magazine ban. And we're seeing a lot of states here who are promoting these bans say that, well, magazines don't even constitute arms, therefore there's no constitutional protection, and therefore we can ban them whatever we want. And the danger being is they may have picked 10 rounds as the arbitrary number right now, but what happens when it turns out to be 3 or 2 when the legislature gets their hands on it? But as the Department of Justice wisely points out, when it comes to these bans on accessories, the act violates the Second Amendment by banning the possession of magazines and other firearm attachments that are in common use by law-abiding citizens for lawful reasons. As this court has recognized in the past, Second Amendment protections extend to certain important corollaries of the core right to possess arms for self-defense and other lawful reasons. The right to keep arms necessarily involves the right to purchase them, to keep them in a state of efficiency for use, and to purchase and provide ammunition suitable for such arms, and to keep them in repair. Well, if we have the same constitutional protections to all the ancillary rights necessary to exercise the core right, the Department of Justice is completely correct when they state, applying that principle to the Act, the Second Amendment protects firearm attachments that are useful to the exercise of the right, including magazines and suppressors. That is huge, because let us remember that there is a 3-judge panel out of the Fifth Circuit that has ruled that, well, suppressors don't even have Second Amendment protections whatsoever, which is interesting because under federal law, they are also defined as a firearm, but I digress. But with all of what's going on right now with suppressors, the fact that the United States Department of Justice comes out and says that they are clearly given Second Amendment protections, that is huge. Ultimately, your United States Department of Justice has filed an amicus brief with the Seventh Circuit in which they have argued on behalf of lawful and responsible Illinois gun owners the following. Because the Act bans the possession of magazines and other firearm attachments that are in common use by law-abiding citizens for lawful reasons, it violates the Second Amendment. Okay, listen, we're going to go ahead and link the brief up down below so that you don't have to take our word for it. You can geek out on it for yourself. But America, and I get that some of you were very lukewarm on Pam Bondi, and I wasn't a big Pam Bondi fanboy. I wasn't as critical as some of you were. And I recognize, because I just did this video right here about 18 United States Code Section 922G3 and how the Department of Justice is not letting up on that. Okay, so there's been some good, there's been some bad. And our job as content creators, I believe, is to report objectively and let you know when good or bad is happening. And what I'm here to tell you right now is the fact that the United States Department of Justice has filed an amicus brief before the Seventh Circuit Court of Appeals on behalf of Illinois gun owners is an amazing day, not only for the Illinois gun owners, but for our entire system of justice. Because as the United States government put at the very beginning of this brief, this case imposes important questions about the scope of Second Amendment protections. The United States has strong interest in ensuring that these important questions are correctly resolved, that the Second Amendment is not treated as a second-class right, and that law-abiding Americans in this circuit are not deprived of the full opportunity to enjoy the exercise of their Second Amendment rights. Huge, huge day on behalf of gun owners everywhere nationwide. Huge day for the United States Department of Justice as well. The case, once again, is Barnett v. Raoul. Amicus brief linked up down below so that you guys can geek out on it for yourself. Listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information down there in the description box. If you got an idea for a video we should be doing, you click on that link right there and you let us know all about it. If you want to subscribe to the monthly newsletter, the ability to do that's down there in the description box. And then finally, and most importantly, America, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.